Hi, I'm Erica Cicero with Cicero Law LLC, here with your estate planning made easy moment of the week. This week I want to discuss one of the most commonly overlooked aspects of estate planning, which is non-probate assets. These non-probate assets are those that pass to another without the intervention of the courts, such as life insurance and certain employee benefits. Louisiana allows spouses or heirs to gain access to funds of the decedent prior to the institution of court proceedings to open successions. Unfortunately, many people are under the misconception that upon death, all assets and funds of the decedent are held in a bank, investment portfolios, retirement funds, that it'll all be frozen and handled in the succession. However, there are many assets that can only be handled outside of a will or a trust, which are non-probate assets. The most common non-probate assets include life insurance, IRAs, 401ks, and annuities. Let me give you a common example of when a non-probate asset can cause issues if these assets are not properly addressed by your estate planning attorney. Bob works for a large company for 40 years as an electrician. His company matches his 401k dollar for dollar. During his career, Bob manages to save $1.5 million in his 401k. Bob is married to Lori, and they have been married for 30 years and have 2 children. When Bob initially was hired as an electrician when he was 19 years old, he designated his girlfriend at the time as his beneficiary for his 401k and his life insurance that his company provides if he passes while he's an employee at the company and not retired. A pretty common benefit that many companies offer. Bob never thought about his beneficiary designation after he filled out his initial paperwork for his job. Bob and Lori have a sweetheart will, meaning that they are each other's heirs. So if Bob predeceases Lori, then Lori inherits as naked owner Bob's entire property. Their will includes the mention of his 401k and the life insurance that his company provides that he naturally wants to go to Lori. Well, 6 months before Bob was set to retire, when his work was still providing the life insurance because he was still an employee, Bob died of a heart attack on the job. He neglected his health for many years, and that neglect caught up with him. Lori was grateful that although she had a rough road ahead without her husband, he saved and provided so well for her future with his life insurance and 401k. Lori quickly finds out that the sweetheart will that she and Bob created is not sufficient to establish Lori as the rightful beneficiary of Bob's 401k and life insurance. Instead, his girlfriend, whom he had no contact with for more than 35 years, is set to inherit his 401k and life insurance. If Bob and Lori had called Cicero Law LLC, I could have helped them to make sure that their non-probate assets were up to date with beneficiary designations that would reflect their wishes and not the wishes they had when they were 19 years old. Unfortunately, this kind of situation is very common, and one spouse is left without recourse to inherit as a beneficiary the non-probate assets, even though the spouse who is no longer living has a will stating what his desire was, as Bob had the will stating that he wanted Lori to have everything. If you're interested in creating an estate plan that ensures you have a proper beneficiary designation on all of your non-probate assets, please contact my office. My contact information is listed below. If you haven't already done so, please like and subscribe for more videos like this.